on general laws. And Senator Holzman, it's nice to see you with us today.
Thank you, sir. Nice to be here.
Madam Secretary, in honor of the fact that we have a very full committee member representation today, why don't you call the roll?
Chairman Nieves.
Here.
Vice Chairman Shaw. Senators Lagla,
Here.
Romine,
Here.
Sylvie, Holzman,
Here.
Nasheed.
All right, we have a quorum, so we will begin our hearing today. I see a few new faces. Do we have, I know we have one person who's properly, not only is he using the proper equipment, but already has his yellow form that he's filled out. Does anyone else want to videotape today's proceedings? You're welcome to make audio recordings all you want. If you're going to make a video recording, we just ask that you fill out one of those magic yellow forms like that young man has done. Anyone else? No other videographers today? Very good. All right, well, we just had two bills that we're going to hear today. I will be presenting both of those, so we will have our very capable Vice Chairman take over. These are both bills that we've heard last year, so I'll go through them very quickly. And right now, I'll turn it over to Senator Shaw.
Okay, we're going to open up our hearing on Senate Bill 622. Senator Nieves.
Thank you, Mr. Chairman, and members of the committee. For the record, Senator Brian Nieves from the 26th Senatorial District, and here to present to you again Senate Bill 622. Senate Bill 622, I think, is one that myself and Senator Holzman, as well as any of the other members of the committee, will enjoy working together on. It has to do with due process and protection of citizens' rights under the U.S. Constitution. This bill specifically pertains to the National Defense Authorization Act of 2012, and specifically talks about Section 1021 and 1022. And since we have already heard this bill last year, it is the exact same bill, and we are the same committee members. I'll just quickly refresh your memory on this bill. This bill, in the beginning, the first page and probably first half of the second page, reminds us of the amendments to our United States Constitution. I would draw particular attention to Amendment 6 and Amendment 14. Those are listed on page 2, line 31, and then line 36. And basically, the entire crux of this bill simply says that the General Assembly finds that Section 1021 of the National Defense Authorization Act for fiscal year 2012 purports to assert the President of the United States, no matter who that President may be, authority to not only arrest suspected terrorists, but also determine whether or not a trial, including what type of trial, will be held for those arrested. Section 1022, and I'm on line 45 of page 2 right now. Section 1022 of the National Defense Authorization Act for fiscal year 2012 requires detention without trial by the military for a certain class of terrorists and authorizes, although not requiring, the same for U.S. citizens. Basically, what we are saying in this bill is that the state of Missouri is going to hold true to our Bill of Rights, and that Missouri citizens will always have due process regardless of subject matter. As a 10-year active duty veteran of our armed services, I don't think there's anyone that would be more in favor of prosecuting terrorists than I am, but I believe that our zeal to do that should not include being able to arrest and detain American citizens without due process. So the intent of this bill, Senate Bill 622, is to make sure that does not happen in the state of Missouri. I'm not sure who we may have to testify for, against, or for informational purposes only, but obviously we'll be calling those people forward. I'll be happy to answer any questions you may have in the meantime.
Does anyone have a question? Senator Holzman.
Thank you. Just real briefly, tell us what happened last year. Where did the bill end up?
You know, as would happen with many bills, we heard it in this committee, voted it out of this committee, and it had a similar fate to most bills, and that is it just never made it all the way through the process.
Did it have Senate floor time last year?
I don't
remember
I don't believe
debating
so.
it.
Yeah, I don't believe so. I handled quite a bit of legislation last year, so I don't think we did, I don't think we had any full time.
Okay, thank you.
Further questions? Seeing none, would you like to call a witness? or-
None that I would call by name, but there may be some.
Does anyone here wish to testify in favor of Senate Bill 622? Does anyone here wish to testify in opposition to Senate Bill 622? Anyone on an informational basis? Seeing none, that closes the hearing on Senate Bill 622. Next, we have Senate Joint Resolution 38. Senator Nance.
And deja vu all over again, Mr. Chairman, members of the committee. This is also a piece of legislation that we heard in this committee last year. It is the exact same as it was last year, so I'll be very brief. And what I would do in my attempt to be brief is read just the very first sentence of the bill summary that says, upon approval by the voters, this constitutional amendment prohibits the Missouri legislative, executive, and judicial branches of government from recognizing, enforcing, or acting in furtherance of any federal action that exceeds the powers delegated to the federal government. Then I would just bring your attention on page 1, section where it talks about section 35. It says that the state of Missouri hereby enforces its constitutional sovereignty and the sovereignty of its citizens under the 10th Amendment of the Constitution of the United States of America over all powers not enumerated and delegated to the federal government by the Constitution of the United States of America, nor prohibited to it by the states. And then the last thing I would draw your attention to, before I'm happy to answer any questions, is the very last section where it talks about the actual ballot language. The ballot language would read like this: Shall the Missouri Constitution be amended to prohibit the state of Missouri from recognizing, enforcing, or furthering any federal law, executive order, judicial, or administrative ruling, collection of revenue, dispersal of revenue, or other action by federal government that exceeds the limited powers enumerated and delegated to the federal government by the United States Constitution. So again, Mr. Chairman, this is a bill that we have discussed in years previous. I'm happy to answer any questions there may be.
Are there any questions for the sponsor, Senator Holzman?
Thank you. I have two questions. As much as I like 622, I'm not sure I care for this one as much. My question is twofold. One, the federal health care law that was passed by both houses of Congress, signed by the President, and then upheld by the Supreme Court. If that has gone through those due process of legislative action and now is deemed the law of the land, if the Supreme Court has ruled it so, how would that impact what you're trying to do here?
We would need to determine that as a body, as a legislative body. Of course, the Supreme Court in that ruling talked about the Healthcare Act as a tax, and so they may have, in doing so, they may have figured out a way to get around this particular SJR. I wonder if perhaps they had read my SJR before they made that ruling and did it in such a way that we might have a little challenge addressing it with this SJR.
Okay, and
And
then
you
my...
notice I did not mention you by name when it came to this one.
Yeah, I appreciate that. And then my second concern really is, in 1964, when the federal government passed the Civil Rights Act, there were many parts of the country, really the country, Mississippi and otherwise, that resisted implementing civil rights. And it took the federal government, and it took the National Guard to escort children to schoolhouse steps to make that happen. If we look at gay rights as being the next sort of civil rights that will be granted in the coming decades, how would this, if passed, affect that? And if this were in place 50 years ago, would the Civil Rights Act not been able to be implemented in Missouri?
I'm only 48, so I can't speak to what may have happened 50 years ago, but I will tell you, in the state of Missouri, we already have our Missouri Constitution already addresses the subject of same-sex marriage, and so that's something that's already in our Constitution. So I don't know where this SJR would either strengthen or weaken what we already have in our Constitution.
Well, those rulings or the statewide bans are being overturned across the country, and of course with the federal government having issued their position on the subject, I think that if it's not clear now, I think it's definitely going to be clear that this is something that I think our citizens are going to have the right to do in the next 10 years. And I would be concerned that if this law were in place, when the 1964 Civil Rights Act were implemented, that it would cause conflict between that and it would allow states to hide behind abusive rights. And so for those reasons, I'm probably not going to support you on this one, but I appreciate the
But you like the other?
I like the other one.
If I can go 50-50 with you, I think I can do that.
Thank you, Mr. Chair.
Further questions? Seeing none, do you have any witnesses?
None to call by name, but I think there are.
Okay, does anyone wish to testify in support of SJR 38? Please come on up. Be sure to fill out a witness form and tell us who you are and what you'd like to say.
Mr. Chairman, members of the committee, my name is Patty Skane. I'm the Executive Director and a registered lobbyist for Missouri Right to Life. We're here to testify in support of SJR 38. We know that the federal health care bill provides coverage for abortion. I'd like to quote, the President, and this is Representative Joe Pitts from Pennsylvania, the President promised when the health care bill was passed that it would not cover abortion. We knew that was an empty promise as the bill stipulated a $1 a month surcharge for plans that covered abortion. Millions of Missourians object to paying for abortion with their insurance premiums or their taxes, and they should not be forced to participate in that. In addition, we believe the Obamacare is financially unsustainable at the quality of care, the health care that we have now, and therefore we believe that will lead to rationing and put the elderly specifically and the disabled at risk. And so for those reasons, we believe that the Missourians need to have the right to not participate in a health care program such as this.
Okay. Questions of this witness? Seeing none, thank you for your testimony. Be sure to fill out the witness form. Anyone else wishing to testify in support of SJR 38?
Thank you. My name is Mitch Hubbard from Callaway County. I will try to be brief. I strongly support this piece of legislation. I believe that essentially it restores the proper balance of federalism. If you look at to paraphrase James Madison, who's the father of our Constitution, in the Federalist Papers, he said that those powers enumerated to the states were numerous and indefinite. But those powers, given to the states were numerous and indefinite, but those powers enumerated to the federal government were few and defined. I don't think, regardless of what side of the aisle we're on, anybody would object to the fact that the federal government has grown over the years. And I would submit that growth has come at the loss of the proper balance of state rights. And I believe that this addresses that and will restore that balance. Therefore, I ask that you vote in favor of this legislation.
Questions of this witness? Seeing none, thank you so much for your testimony. Be sure to fill out a witness form. Anyone else wishing to testify in support of Senate Joint Resolution 38? Seeing none, anyone wishing to testify in opposition to SJR 38?
Mr. Chairman, thank you. I think I'm part of your microphone here. I'm Pamela Michael Sumners. I'm the Executive Director of NARAL Pro-Choice Missouri, and also am a constitutional and civil rights lawyer. You may detect from my accent that I am not originally from Missouri. I am from the semi-sovereign Republic of Alabama, where our state motto is, if at first you don't succeed, try again. And when I read the language of this resolution, it is just like reading a declaration of secession hot off the pen of John C. Calhoun. The federal government is not the enemy of the states. A balance was struck a very long time ago between state autonomy and the authority and responsibility of the federal government. Federal law is in fact supreme. The state of Missouri cannot secede from that. There are any number of things that I personally, as a citizen, would rather my taxes not pay for. Henry David Thoreau felt the same way in 1848, but you must pay your just taxes, you must abide by the law, and that does mean, in our case, the federal law. And I would like to say a couple of things about the Second and the 10th Amendments. These seem to be the only amendments that are popular in the chambers these days. But the 10th Amendment has been relied on by the United States Supreme Court only twice as a bedrock of decisions in the last 50 years. One of them was to strike down D.C.'s gun control law. And before that, the 10th Amendment was always relied upon to legitimate, say, Plessy versus Ferguson. I don't think that the state of Missouri wishes to have more in common with the state of Mississippi than the first four letters in the name. And, you know, sovereignty is a fine word, and it shouldn't be trashed by base motives. I'd be happy to answer any constitutional law questions you might have.
Does anyone have any questions, Senator Holzman?
I really don't want to be flip about this, but the most important sovereignty is that of individual sovereignty. And, you know, rather it's the state or it's the federal government. When we authorize authority over us, we give our consent to be governed, and that's on an individual level. And I would suggest that your organization representing women's right to choose protects individual sovereignty as well as any organization in this country. And wouldn't that sovereignty be eroded if a bill like this were to go into effect?
Oh, there's just no question, and I haven't parsed down every bit of this bill, but I can't find one thing in it that I like. I hadn't really thought about it as a bill about abortion or Obamacare until today. But for those who like to rail about nationalism and socialism, I would say that nationalizing the womb is kind of pretty much the ultimate socialism, and I think you're right. The ultimate sovereignty is what we as individual citizens in this country get to choose for ourselves and our families.
Well, I know that Senator and I, we definitely agree on protection of our sovereignty, our individual sovereignty, and we differ on that particular subject, but I think it was fair to point that out, that we're inconsistent when we're leveling whose sovereignty we're willing to protect. So, thank you very much.
Any further questions? Seeing none, thank you. Be sure to fill out a witness form.
Thank you. I had forgotten. Thank you so much, Chairman.
Anyone else wishing to testify in opposition to SJR 38?
My name is Michael Stanchi, and I live in Arnold, Missouri, Jefferson County. Paul Whelan is my state rep. I'm a lifelong Missourian, but for the last 3 years we've lived in Florida. And it was there that I obtained my bar license, practice law there. And last week I took the Missouri bar to obtain it here, and actually I have a temporary license. I actually don't oppose the bill, but I'd like to give some insight into some subjects that it discusses. And I guess first of all, I'll vote for it if it's on the ballot, I can assure you. But understand, the U.S. Constitution has a supremacy clause. I believe it's in the 5th or 6th article. And it explicitly states it's the law of the land. As has been the 1964 Civil Rights Act or any other, the state laws have to submit to the federal law. So if the United States Supreme Court, heaven help us, says, men and men can marry, it will overturn Missouri state constitutional law, end of sentence. So another constitutional law saying you can't exceed your boundaries, they're going to say, no, we're interpreting it as within the boundaries, end of sentence. It's wonderfully symbolic. And as I said, I'll be voting for it. But I think there's a better way to approach it and achieve your goal. It's too broad. Be specific. Unfortunately, no state legislature, in recent history, has successfully, by state initiative or state legislature or constitutional amendment in the state, banned abortion. But what have they done, including Missouri, is they've restricted it out the wazoo. Parental consent, waiting periods. Was it Mr. Blunt, when he was governor, the bill was he signed, you had medical equipment and doctors had to be licensed or had access to the local hospital, and one of the abortion clinics, I believe, in Springfield, shut down because they couldn't comply or didn't want to. It worked. If you're going to find such immoral and evil behavior as murder or sexual perversion, then you're going to have to be, and besides, as you can see every day in the news, gay rights, homosexual rights, the alleging of it, is a development of law. It started in 2003 with the Supreme Court striking down Lawrence versus Texas. Versus Lawrence. And it has progressed since then. In 33 odd states saying no marriage like that, a dozen saying sure, you can do it, and all kinds of cities and states allowing discriminatory laws or preventing them. St. Louis, sexual orientation is prohibited as a discriminatory practice. That's where you attack it. Propose a state statute that says no city, municipality, or governmental entity in the state of Missouri can bar somebody from discriminating on the basis of sexual orientation. That'll shut it down. All of a sudden, what's happening in Arizona or New Mexico, whatever the state it was, and the governor vetoed a bill that would have said, no, you're a Christian, and you say, hey, I'm a baker, and I'm not selling you a cake to you two ladies to get married. Well, all of a sudden, that problem has just got solved in Missouri. Somebody does that in St. Louis, they're going to be criminally prosecuted and possibly civilly, depending on the statute, that ordinance that St. Louis City has. And I don't know, maybe Kansas City and Springfield or a few other little cities. So you want to construct this in a manner that is specific and to pick it apart. If you got a perceived evil, you pick it apart. Just like abortion has been done. And the mood is generally changed. And it's still a live issue, 40 odd years after the fact. And it won't go away for the people who espouse it and want to hurt their babies. You pick it apart. You got to get public opinion. This is great and symbolic, but it's too broad. It's not specific enough. That would be how to address. That would be my recommendation. You'll win. You'll win off all these small little battles. All the little battles add up. The lady before me made reference to the Second Amendment. I just was in the House committee here in Southern. Mr. Jones is the chairman. 5, 6, firearm bills. Every one of them pro-Second Amendment. Picking it apart. Picking and winning every little battle. That's how you do it. But if you're going for the stab in the heart, then you need a constitutional amendment to the United States Constitution, or you flat out change 5 out of 9 U.S. Supreme Court justices. And that's not as quick as picking it apart. And you got control of it.
I have a question. So your main premise is that once the United States Supreme Court rules on something, it becomes the law of the land, and Missouri is not able to really fight it. That's your main premise, right?
That's correct.
Okay, well, so up until that point, if Congress then passes a law that is the law of the land, from time to time, Congress passes laws that are unconstitutional.
Correct.
And so this bill is basically saying, if the law that Congress passes is unconstitutional, we're not going to follow it. I suppose, isn't that?
Well, and what's going to happen, let's say you, I mean, with reference to the lady that previously succeeded me, National Abortion Rights Action League, okay, great, you put up a constitutional amendment that bans abortion, period. You know, except for the first trimester. Okay, what's going to go? It's going to go right to a federal judge. They'll be the first to jump on it. And they're going to get an injunction, which means it doesn't take effect until a full hearing in court takes place. It'll go through the appeal system if the Attorney General wants to push it, after the district court, and then if the appeals say, no, it's still no good, then the United States Supreme Court will take it if they want. Otherwise, they're going to defer to the appellate court.
So how come it is that the federal government can ignore a law that the Supreme Court has already ruled on, but the states can't? Like, for example, we already know, according to the Supreme Court, that the federal government can regulate controlled substances. Colorado passes a law that allows marijuana to be sold legally, completely contrary to federal law, but yet the federal government just ignores that and looks the other way. They can do it, but we can't.
You said it. DOMA. What did our president?
What about the ACA? We've already heard that the ACA has been ruled on by the Supreme Court. The federal government can ignore the plain language of the ACA, put back the employer mandate by a year. In fact, they did again, they put another mandate back. The federal government can just ignore the federal law that's already been ruled on, but we can't. So how does that work?
You know, it's all going to end up in a courtroom, and it's going to be the judge that decides, or the appellate court that decides. It's the United States Supreme Court. And yes, you're wondering, everybody scratches their head because it's not a hidden secret. The accusation of our president ignoring federal law, and he's probably not the first. I haven't done any kind of history on it. You know, until push comes to shove, and it's in front of a court, and there's a judgment by a judge or the appellate court, and it's been a review, you know, they're going to do what they want, unless an injunction is imposed. If nobody's taking up the cause and files suit to stop or to force a behavior, and then you get into this idea of enforcement of laws. There's a lot of law enforcement in general has a lot of discretion as to which laws to enforce. Cop doesn't have to give you a ticket. Cop doesn't have to execute an arrest over a man or woman having a good fight in the house, where, you know, she gave him a bloody nose and she's got a nice bruise on her face. Cop can say, you know what? Is everybody safe now? Yeah, we got it out of our system. And you walk out with no arrest. You and me, we're looking up like, holy cow, somebody needs to go to jail. He doesn't have to enforce it. He uses judgment. That's going to be a part of the play, but again, it's just flat out, somebody's going to push it and go to federal court. And that means money and will.
Further questions? Seeing none, thank you for your testimony. Be sure to fill out a witness form. Does anyone else wish to testify in opposition to SGR 38? Okay. Seeing none, anyone wish to testify on an informational basis? Seeing none, Senator Nieves, do you have any closing comments?
Well, Mr. Chairman, I might note that perhaps that last witness might be considered informational purposes only because you support the bill but want to give information about how it can be made better. Typically, we list that as informational purposes only. The other thing I would
He's
say
okay with that.
is that, you know, one of the things in the 12 years I've been in this building is it's amazing to me, you know, how people will claim that cows fly or pigs whistle. And saying that this SJR is about secession is about as truthful as saying that pigs whistle and cows fly. This bill has nothing to do with secession. This bill is entirely about the state of Missouri recognizing the relationship that we have with the federal government. In fact, I underlined something that I had here, and it's from Article 6, Clause 2 of the Constitution of the United States that provides that laws of the United States are the supreme law of the land. When you hear people that want to assert their opinion that the federal government is the supreme ruler and that states have no authority and states have to line up and do whatever the federal government says, they oftentimes talk about this so-called supremacy clause. But what I would bring to their attention is that's not the end of the sentence, right? It doesn't just say, the Constitution of the United States provides that laws of the United States are the supreme